Good morning, everybody, and welcome to the latest Backing Brentwood Business webinar brought to you by Brentwood Chamber of Commerce, Brentwood Business Partnership and Brentwood Borough Council. My name's Colin Barber. I'm Chairman of Brentwood Chamber of Commerce, and it's my pleasure to host today's webinar, which is the latest in a series of webinars brought to you over the past few weeks during the coronavirus crisis. The objective of the webinars is to help you run your business during these difficult times and to give you some tips and help and advice on how you can get through the times ahead of us. Today, our special subject is brought to you by Tees Law, one of the large firms of solicitors with offices in Brentwood, and the title is Commercial Contracts and Consumer Rights. Today, we'll be talking to Ana James-Pittau from Tees Law, and she's a solicitor based in Brentwood. We were actually due to hear from Jez Gibbs as well, who works in the same office, but unfortunately he has been called away on some urgent business. So Ana James will be running the webinar this morning and hopefully dealing with all your questions in relation to commercial contracts and consumer rights. Just to flag up, if you are not familiar with webinars or with Zoom, if you haven't used it before, there are a couple of options for you at the bottom of the screen, normally at the bottom of the screen, depending on the layout of your computer, for you to access. One of those is Q&A, which is the important one. So if you have any questions which you'd like to put to Ana, then do hit the Q&A button, and I'll ask her the questions at the end of the webinar. If there's anything you want to mention to me or to Ana during the webinar, then feel free to hit the chat button. But I say the main button to be using is the Q&A button for any questions you've got regarding commercial contracts and consumer rights. As I say, the webinar today is the latest in a series. All the webinars are uploaded to our Brentwood Chamber of Commerce YouTube channel. So if you don't manage to watch all of today's webinar, if you want to catch up on any of it, then by later on today it should be available for you on the YouTube channel. Or indeed, if you'd like to see any of the previous dozen or so webinars which are on the YouTube channel, then just search for Brentwood Chamber of Commerce on YouTube and you'll see all the webinars, the past webinars which have been uploaded there for you. So most of all, really, I'd just like to thank you all very much for joining us this morning, and hope you do find the webinar informative and helpful. And if there's any points which you do want clarifying, then as I say, do just hit the Q&A button, and I'm sure Ana will be able to elaborate on some of the points for you. So let me just check. Ana, are you there? If you'd just like to unmute.
Yes, I'm here. Thanks, Colin.
Great. Good morning, Ana, and welcome to today's webinar. We're looking forward to hearing from you and all about the law and how it's been affected by the corona crisis. I take it you've been working at home for the past few weeks?
Yeah, so we've been working from home. We were actually due to start working from home before we went into full lockdown, so we were fully prepared for it, which was great. Yeah, we've got good systems, so we've got all the right equipment, which has enabled us to carry on as normal, really.
Yeah, okay, yeah, good.
Yeah, good.
And are clients quite happily communicating with you by email or Zoom or whatever?
Yeah, I mean, it's quite usual for the types of clients we deal with anyway. I think certain departments, for example, private client, it's been slightly more difficult perhaps, and more face-to-face meetings have had to be arranged in the office. But for us, Zoom meetings, telephone calls and emails have worked really well.
Good, okay. So how long have you been at Tees then, Ana?
I joined Tees in October last year, so I'm still quite a newbie there, really. Although time is going a lot more quickly, I realise, since lockdown. I keep saying 6 months, and actually the last 3 months just seem to have not happened, really. So yeah, just for the year I've been with Tees. Right,
okay, good. So yeah, strange times for all of us. Anyway, I'm going to be running the PowerPoint slide on your behalf, Ana, so during your presentation. And just one final reminder, if you've got any questions for Ana, do hit the Q&A button and just type your questions in. I won't ignore them. I'll be reading them during the presentation, and at the end of the presentation I'll put the questions to Ana. So let me just do a shared screen, and once we've got the slide up and running, and I'll pass it over to you, Ana. Let me just bring it up. Yeah, so over to you, Ana, and just let me know when you want me to advance the slides.
Great, thanks, Colin. So today we're going to talk about commercial contracts and a little bit about consumer rights, and I'm very briefly going to cover competition as well, just because it's an area quite of interest that may relate. It may not directly apply to your businesses, but it's quite an interesting development that's happened as a result of COVID. But I'm going to focus mostly on contract provisions and relying on them and the practicalities of dealing with issues you may have experienced in light of COVID-19. So if we just move on to the next slide. And it's just a summary of the things we deal with at Tees here. We're a full service law firm, so we can cover all matters that arise in your personal and professional lives. I myself am in the dispute resolution department. So as a team, we deal with all matters of dispute resolution, from commercial property matters, as well as contested probate and things like that. We also have an employment department, corporate commercial, transactional department, as well as our normal property transactional departments and things like medical negligence, private client and family matters. If we can just move on now, Colin. So just a little summary of Tees there. I won't go into that too much. We cover 6 of 6 locations across Essex and the borders of Hertfordshire, so we cover quite a wide area. But also, because of the way we work, our systems, we do service clients from all over the country as well. So we're not restricted to those areas that we can service for. Thanks, Colin. So just a summary of the things we'll be talking about today. So I'm going to cover force majeure, both what is it and then the practicalities of relying on it. Frustration, which is sort of an alternative to force majeure. Contract balancing, which is less of a legal principle, more of a practical and commercial considerations. Consumer rights, so they're going to be things that you need to consider in dealing with your customers potentially, and also things that the rights you have in your personal capacities. A little bit about unfair trading and how to stay on the right side in light of many kind of scary stories that came about at the beginning of coronavirus and the lockdown. And just as I said earlier, a little bit about competition and what's changed. And then some government guidance that's been released on behaviour and what's expected in dealing with issues at the moment. So if we start with force majeure, big question is, does COVID-19 qualify in that respect? So force majeure is a clause that will be found in a contract. It will be an express provision in your contract, so it can't be implied into a contract that it doesn't expressly, is not expressly written into. And the wording of it will depend on whether COVID-19 can qualify, and there's various different ways that a force majeure clause can be worded. It may include specifically situations such as epidemics and pandemics, or it could use more catch-all provisions such as events outside the reasonable control of the party, or acts of God. Now, an act of God, again, whether or not that is set out in your contract, it may be set out in various different ways, and it may make a distinction between naturally occurring events or government actions, of which perhaps lockdown would fall into, or it may again specifically define things like epidemics, pandemics. If your contract isn't, if those matters aren't defined, and it's not clear whether COVID will fall into it, it's going to be a matter that we'll need to wait to see really how courts interpret unclear provisions as to whether or not COVID falls into it. You would think that an act of God, if it's a wide definition of that, you would hope COVID-19 would apply. However, previous exceptional circumstances and major events have not been determined to constitute an act of God. So things like exceptional storms and changes in economic markets. So we will have to wait to see how courts do interpret various different types of wording in contracts where, for example, the specific wordings of epidemic or pandemic aren't used. But the other thing to consider is, even if something that COVID-19 doesn't seem to fall squarely into isn't set out, is whether, like I mentioned, a government action, perhaps in response to a major event, is dealt with, because most likely for most businesses, it's going to have been lockdown rather than COVID itself that's caused any difficulties. The key thing about force majeure and the reliance on it is the event that triggers use of the force majeure clause has to have been unnecessary. Has to have been not within the reasonable scope of the parties at the time of making the contract. So it can't have been in the reasonable contemplation of the parties that such an event would occur. And it has to have affected the performance on that contract. So if we can just move on to the next slide and deal with the practicalities of relying on it. So as I was just mentioning, lockdown or COVID has to have been the direct cause of not being able to fulfill your obligations under the contract. And the effect of your performance and whether the force majeure clause will cover that will again depend on the wording of the contract. The contract may state that your performance, if your performance is suspended, then the force majeure clause will apply, or it may be that it has to have absolutely made it impossible for you to perform that contract. And again, the clause might also deal with what will happen and what the arrangements will be for moving forward if your performance has been affected, and whether your obligations can just be suspended or if the contract needs to be absolutely terminated, because it will just mean that the purpose of the contract is no longer possible at all because of the effect that COVID-19 or lockdown has had on your performance. Now, what's really key is that you cannot simply rely on the fact that there has been this a rise of this pandemic, or the country's been, or the world has been put into lockdown, by relying on a force majeure clause and being able to say, well, you know, I'm not going to bother, I don't need to perform my obligations. You do need to try and mitigate the effects of the event in order to be able to benefit from the protection of a force majeure clause. So that will be, that's why it's really key to establish what the actual impact was. Was it COVID directly or was it lockdown? What the direct impact of that has been on your performance, and what you can try and do to mitigate that. Are there any alternative solutions you can put in place to ensure continuance of that contract and performance of your obligations in some form or another, whilst of course following the government guidelines? It's also going to be really important to consider the notice provisions of your contract, because again, you can't just sit back and say, well, obviously everybody is experiencing lots of difficulties, I don't have to perform. Your ability to seek protection of a force majeure clause is much going to depend on serving the appropriate notices that the contract's going to provide for, depending on what you're going to want to happen next, or what can happen next as a result of the wording of the contract. So if we just move on to frustration. So frustration applies when you do not have a written contract, or your written contract does not contain force majeure provisions. Now, the burden of reliance on frustration is a lot higher than force majeure, because in order to be able to rely on frustration, it has to have been physically or commercially impossible to fulfil the contract. So rather than hopefully a force majeure clause being more flexible and that perhaps performance can be suspended or delayed, frustration will only apply if it is completely impossible. And also the effect of frustration is that it will bring the contract to an end completely. So rather than there being alternative solutions perhaps that can be arranged, force majeure frustration will bring the contract to an end. So courts are generally very hesitant to interfere, particularly in commercial contracts, between business to business contracts. So they will only do so if absolutely necessary. So if it's possible, frustration should be the last thing that you seek to rely on, really, because it can be difficult to do so because of the high burden on the effects and then the impact that frustration will have on the relationship. And again, the same will apply in relation to mitigating your position. So you can't just sit back and rely on COVID or lockdown to be able to, in order to not perform, you will need to see if there are other ways around it. So if we can just move on to contract balancing now. Many businesses will be facing the dilemma that perhaps they have enough resources to fulfil some of their contracts, or perhaps part of all of their contracts, but not in their entireties. And there is no principle of English law that says, or that tells you how you have to deal with it in those circumstances. You may have provisions in contracts that will guide you and will set out legally what the position should be, or what contracts you may need to have particular regard to. But overall, it's going to be a balancing act based on various different things. So some contracts may have preferment clauses within them that will say that you need to rely on them over others. Others may have good faith obligations in them, and therefore if you were to prioritise more lucrative contracts over those with good faith obligations, then you would arguably be in breach of those good faith obligations and therefore in breach of contract. What contracts have the harshest consequences for breach or the greatest rewards for delivery? That's going to be a commercial consideration. Can you afford to take the hit on some because they have less harsh consequences if you are in breach, or do others mean that if you perform and perform well, you're going to win future other business that will specifically help you in continuing to trade, particularly in these difficult times. Other contracts might have limitations on liability, so again that ties in with the harshest consequences. If some limit your liability for breach, then it may be worth considering those for non-performance rather than others, which the impact will be higher if you can't perform. And is there a moral aspect to it or a public policy angle? If you're supplying the NHS, for example, their need is probably greater than others at the moment, or particularly vulnerable customers if you're dealing with consumer matters. Which of your customers is better able to bear failure to deliver? For some, if you can meet the extent of the delivery that you're required, it may save company from the brink of insolvency. Whereas with others, if they are really on the brink of insolvency and you make your delivery, you perform your side of the contract, will they be able to perform theirs, or will actually it not really make a difference and they're going to unfortunately go under anyway, and then you're putting yourself at risk as well. And insurance policies. Consider whether you have any insurance policies that will cover you for any particular contracts. If you do for some but not for others, then perhaps they're the ones that you're going to choose to not perform. But again, be very careful in terms of the insurance policy wording and their requirements to make sure that you will be covered. And consider your reputational risk. Will some have a greater reputational impact for you if you can't perform than others, or will some increase enhance your reputation if you are able to perform and be more benefit to your business? And are some of your customers particularly litigious and more aggressive? Will they be more likely to sue you for breach than others? And consider, like I mentioned at the beginning of this slide, is it better to under-deliver to all rather than not being able to deliver at all to a few and being able to fully deliver to some? That's going to be a balance based on all the things I've just covered. And again, consider mitigating your position. So this will probably particularly rely to whether you've got insurance cover, how can you get around it, what can you do to try and meet the expectations, mitigate your position, and liaise with your customers. You may be able to find a workaround that actually works for everybody and avoid disputes at all. And make sure you keep records of your decision-making process, why you've chosen to perform some contracts over than others, the effects that the COVID-19 or lockdown has had on your ability to perform, because if you do find yourself in legal action, they will help in setting out your defence and justifying your decision. So we just move on to consumer rights now. So there's going to be more and more online purchases taking place. Depending on your type of business, you will be receiving more online purchases. Perhaps you're a business that's never really done online business before. And also you're probably making a lot more online purchases yourselves. So it's really key to know what your rights and your consumers' rights are. Particularly when you're purchasing through a distance contract, so maybe you've not physically gone into a shop and chosen to purchase a particular good or enter into a particular service. Customers have the right to withdraw within 14 days and that's making the contract and also receiving the goods. So if they decide once they've received the goods that they don't want them, then they have the right to return those to you and receive a refund. If, depending on the reason they're returning those goods, if it is just a change of mind, then they will have to bear the cost of that refund, of the return to you. That's not something you are obliged to provide. And also you may be able to reduce the refund to account for any enhanced delivery costs that you incurred by choice of the consumer. Also, if you receive the goods back and you find that the goods have had more use of them than you would expect for someone just to decide whether they wanted it or not, then you adjust the refund accordingly, perhaps, or potentially refuse the refund. Keeping documentary evidence of the goods as they go out and when they're coming back in, taking photographs is going to greatly help you in circumstances where that might be an issue. Now, the other side of the coin is if goods received by the customer aren't actually of good quality. If there's a fault with them, if they're not how they were advertised, then customers will be entitled to receive a refund. And that will be a full refund within 30 days of receipt of the goods. And after that time, they will be entitled to repair or replacement. Goods are generally expected to or assumed to have had any default within the first 6 months of delivery. So it wouldn't be down to the customer to prove that it was there when they received the goods. If it has arisen within the first 6 months, then it's assumed that it was there when they received them. So that's just something to bear in mind. 6 months may seem like quite a long time, but just be aware of that if you're receiving such complaints. If a repair or replacement can't be provided within a reasonable period of time, or particular inconvenience is caused to the customer in the meantime of a repair or replacement being provided, then they may be entitled to a refund, either in full or in part, depending on the circumstances. So a prime example is a car. If you purchase a car and it's got a fault within it after 30 days, it's arisen after 30 days, as a dealer, you're obliged to take that back and provide a repair or replacement. Now, if you can't provide a courtesy car, the inconvenience caused to the customer is going to be a lot greater than if you can. And so their entitlement to a refund in what we considered a reasonable period of time is going to affect that. Currently, what will be considered a reasonable period of time is probably going to be longer than normal, because there's going to be perhaps issues with obtaining parts and things like that. But again, document your process, communicate with the consumer about what issues you're experiencing, if you are experiencing a delay in receiving certain goods, in order that you can justify what may be otherwise considered a longer delay or an unreasonable delay. If you can justify the reason for that, then it's more likely than not going to be considered reasonable rather than unreasonable. If a consumer, again, going back to the point about part refunds, if a consumer has had some use out of the car, so again, if, for example, they've had a certain amount of mileage, more so than you might have expected, particularly, again, it's going to depend on the fault that's arisen, then you can perhaps arrange a part refund to account for any use that they've had. The same with service-led contracts. If you have provided part of a service within the 14-day cancellation period, you will be entitled to charge for the service that's been provided. The best thing to ensure that the position is clear for everybody is to make sure that your terms and conditions or your contracts for sale specify what will happen in those circumstances. So if you're, for example, providing a fixed price service, if only part of that service is provided and therefore you can't charge for the full fixed price, set out what the pro rata basis for charging is going to be within your terms and conditions. Set out what your return policies are in terms of delivery costs, etc. Will you be refunding all delivery costs that you incurred if goods are returned in certain circumstances? Having a contract that sets out what will happen in those situations will greatly help you in any times of uncertainty, because you've got something to rely on in terms of what's going to happen, rather than just trying to argue what might be fair and reasonable in the circumstances. Obviously, make sure your terms and conditions are properly drafted and they're not in breach of the Unfair Contract Terms Act, because they won't be enforceable anyway. So if we just very briefly move on to unfair trading. At the beginning of lockdown and coronavirus coming about, there was stories of hugely expensive hand sanitizer, and therefore the Competition and Markets Authority, who regulate such behaviour, unfair trading practices and anti-competition, were very quick to first of all set out a warning to traders that they expect them to behave responsibly and not to inflate prices or make misleading claims about products. And they've also launched an online service which can be accessed for reports to be made against certain traders. They won't directly respond to a particular complaint, but if they're receiving a lot of complaints about one particular trader or a few particular traders or a particular industry, then they will certainly investigate those and take action as necessary. So in terms of, there also may be people that are more alive to the fact that there's these issues arising and therefore might try their luck in making complaints against you or bringing claims against you for unfair trading. So just be really careful that your statements you're making about your products are completely true. That you're not omitting any information from descriptions of particular products, that you're not being aggressive in your attempts to sell. So for example, you're a particularly sales-based business and your employees perhaps work on commission. They may be really keen in times at the moment where things are slower to try and enhance their income, that they might be slightly more aggressive in their sales attempts. So just make sure you're educating them on the provisions of unfair trading and what they should and shouldn't be doing. Particularly in terms of your descriptions of products, if you're selling products, a prime example is face masks, and they don't have particular features that one might expect would come from a face mask. So if they're not particular medical grade, then make sure you categorically state that. Because if it can be expected that a feature of a product would reasonably be assumed because of the nature of the product, if it's not got that particular feature, then just do say that so that you can ensure you stay on the right side of the law there. So if we just move on to competition law, and as I said at the beginning, this is more of an interest point. I don't know how much it will apply to many of you, but the Competition and Markets Authority has relaxed many anti-competition laws in order to ensure continuation of the supply chain in particular industries. So it relates to the healthcare sector, unsurprisingly, supermarkets, and also dairy farmers in particular. So the relaxation of the rules has meant that information relating to stock, logistics, labour availability, and also coordination in relation to access to stores, for example, the change in opening hours, and particularly at the beginning of lockdown for care workers and things, that they can now discuss that information and coordinate their approach in those respects. And also where there may be difficulties with obtaining stock and moving stock around, labour to make sure the services are still provided to the public, that they can also share that, which would normally not be allowed. The reason it would not normally be allowed is because in order to ensure that low prices and good customer services are maintained, particularly leading institutions should not be sharing that information, because if they do, they can all coordinate to hike their prices, and that would mean that everything would be expensive for everybody. The key thing that they are not allowed to share and coordinate and collude in relation to is pricing information, and particularly longer term pricing and business strategies. That's something that the CMA have been very strict in relation to ensuring that and making and advising that they are not to do that, and that's to maintain the value to the public, particularly in relation to pricing. So if we just move on to government guidance and behaviour. So the government, I think, is aware that, particularly in relation to relying on contracts, if we can just move on to the next slide there, Colin. Sometimes contracts will be too blunt, and as you can see from what we've already covered today, they might be unclear as to whether or not COVID-19 may apply, lockdown may apply, and what should happen if and when they do. So the guidance from the government is work together, cooperate to achieve practical, just and equitable outcomes, have a regard to the financial resources of all parties and the protection of public health and the national interest. But better that everybody can work together to try and come to an amenable solution, the better the outcomes will be for everybody. There's going to be some instances where some parties are going to be particularly aggressive, and that's just not going to be possible. But if it is, then the outcomes are going to be a lot better for everybody, rather than trying to rely on sometimes uncertain terms in contracts, and particularly if you've not got frustration provisions and you have to rely on force majeure provisions and you have to rely on frustration, then the position is going to be even more certain. So the best way for everybody to proceed is to just try and work together in order to achieve the best outcomes for everybody. So that's it from me in terms of my slides. I think Colin's got some questions. I've not been keeping an eye on the chat, so I don't know if anybody has put anything through on that. But over to you, Colin.
Great, thanks very much, Anna. Just put a disclaimer up on the screen, as obviously T's want to be sure that you understand that this is some general guidelines for you. Yeah, very interesting, Anna. I guess one point that came out for me was this is about the fact that it's is the problems with the contract caused by COVID itself or by the lockdown, and obviously the difference being that if it's caused by the lockdown, then that does come under, as you say, government action, rather than if it was actually the COVID itself. And as you sort of point out, most of the contract problems probably are caused by government action rather than by the coronavirus itself. And that's a key point, I guess. Yeah.
Yeah, definitely. I mean, I'm for those that have been directly impacted by COVID, there will be a few, I imagine, but I think generally on most businesses, it's going to be the forced closure of them that's going to have had the greater impact.
Mm. And it was also interesting thinking about force majeure, and obviously the obvious question one would ask is, whilst we couldn't necessarily predict there was going to be a coronavirus crisis, you would think, well, maybe contracts in effect, you really, the idea is to try and predict everything. Do most contracts have a force majeure clause, or is there a sort of presumption that is in there, or what's the sort of general?
I mean, it's really going to depend on who drafted it and the nature of the provision. More commercial contracts will likely have those provisions in there, and if they've been drafted by lawyers, then you would certainly expect they would be in there. Others, you know, we do get a lot of customers come to us to ask us to advise on enforcing a contract that they may have pulled off the internet or may have been being used for a number of years, and they might have pieced it together from different contracts that they've had from different sources. So it is really going to depend on where your contracts are from, who's drafted them, as to whether those provisions would be in there.
Yeah, okay. Just to remind those of you who are watching today, if you do have any questions relating to the subjects which Anna's talking about, it may be something you want to clarify from one of her slides, or perhaps something which she hasn't covered, which is potentially affecting you and your business, then do feel free to hit the Q&A button and put your question into us so that I can put them to Anna on your behalf. And you talked quite a lot about mitigation. That was a word which I noticed kept coming up on your slide. It's obviously a key area at the moment in terms of mitigating the problems caused by the contracts.
Yeah, I mean, and it always is when it comes to disputes. You always have to try and mitigate your position. You can't just rely on a particular event or the behaviour of another party, for example, to not have to perform your obligations. Mitigating your position and trying to find a workaround, if possible, is always going to be key, and that's going to be something that courts will expect to see. So, for example, if you've a very easy example is if you've got a vehicle and it starts showing problems, the engine light comes on, and you carry on driving it rather than stopping, taking it to a garage and seeing what the problem is, then you've not mitigated your position. Any issue that's there is probably going to be exacerbated by continuing to use that car. So it's just kind of taking a step back and reviewing the full picture and seeing what you can do to mitigate your loss, because you do have an obligation to do that, as well as, you know, the right to potentially rely on the contract. But like we've seen, relying on the contract might be difficult to apply it to a particular circumstance. Particularly some businesses might struggle to show that lockdown specifically has affected their business, or COVID-19, particularly COVID-19, if lockdown isn't covered in their contract. So it's ensuring your position is best protected, really, as well as ensuring that you're going to be able to rely on certain provisions in court.
Yeah, okay. We've got a question here which refers specifically to one of your slides where you mentioned preferment type clauses. My question: what is a preferment type clause or a good faith obligation? Could you perhaps expand on those?
Quite simply, a preferment type clause might state that you have to prefer that contract over others if you have a difficulty in the supply of, or if you're a goods-based business and you have difficulty in achieving all the goods, that the amount of goods that you require to perform all your contracts, they might state that you need to prefer them over any other obligations that you have to others. And a good faith obligation might state that you need to act in the good faith, in good faith when deciding whether or not to perform that contract. So, like I mentioned in my talk, rather than choosing the most lucrative contract to you, the one that's going to earn you the most money, just because you might, that kind of clause might arise in a public contract, or if you're serving a government agency or the NHS, that you although that might not be the highest price contract, you still need to act in good faith in making sure that you can perform the obligations of that over another. So that they're quite similar in terms of preference, but they might just be slightly different worded in terms of acting in faith or specific impairment.
Yeah. So I'm just thinking an example. So, for example, a large supermarket chain might, in their contract, have a preferment type clause saying that the supplier has to supply them before supplying any other supermarket. Is that the sort of thing?
Yeah, exactly.
Yeah. Okay. Good. That's
particularly if you've got particular competitors.
Yeah. Yeah. So that's quite a smart. Just thinking ahead to the future, that's quite a smart clause for someone to put in a contract, isn't it? If you with your suppliers, to make sure that you are the preferred customer who receives the goods.
Yeah, potentially.
Yeah. Got another question here regarding commercial lease. So it says, potentially, could force majeure apply to a straightforward commercial lease where the COVID-19 situation has rendered a traditional office setup no longer viable? So I guess someone's thinking they don't really want to rent their office anymore.
Yeah, no, force majeure I don't think would, obviously it's going to depend on each individual lease, but I don't think it would generally apply to in the commercial lease context, because there is so many other provisions that apply to both residential and commercial property matters. For example, the procedures that you need to follow in terminating a lease if necessary, and the fact that leases are generally for a fixed term. Often for example, an act of insolvency can entitle a landlord to terminate a lease and forfeit the property. But it's not been something that I've come across so far that it can work the other way around when it relates to kind of an office setup just not being viable in the specific circumstance that you've put. So it's not something directly that would usually, that I've seen apply, but it may depend on the particular wording of your lease.
Right. Okay. And a similar question: when is a non-performance of a contract considered to be a fundamental breach, and what would be the outcome?
So we have two kind of main types of breaches. One is, and the most serious, is a repudiatory breach, which would entitle the party to terminate the contract, and that would be the party that has suffered from the non-performance rather than the non-performing party. And that would generally be where your ability to perform the contract or performance of the contract hasn't happened at all. So going back to the contract balancing element I was talking about, if, for example, you are able to perform, to supply some but not part of an order to all of your customers, rather than all to some and none to others, that's less likely to mean that you're going to be considered, that's going to be considered a repudiatory breach, because at least if you've been able to supply part of the contract, it would be considered more of just a normal breach, for which damages might be payable for the losses that the other party sustained in not receiving their full order, rather than a repudiatory breach if somebody's received nothing from their order. And whether or not it's a repudiatory breach really goes down to whether what's been breached was the core purpose of the contract. So it's going to depend on all the circumstances, but an example would be if you've got a contract to do works on a building site, and the contractor isn't allowed onto site, then that's a repudiatory breach on the part of the main contractor or the building site manager, because there is no way that the contractor can perform their obligations, and the main reason they're there is to work. Whereas if you've received a poor standard of workmanship, then that wouldn't be so much classed as a repudiatory breach, and you would just be entitled to damages for perhaps putting the work right. And the difference is, with a repudiatory breach, you can terminate the contract and seek damages, whereas with a normal breach, you can only seek damages, and it wouldn't necessarily give you the entitlement to terminate the contract.
Right, so that's quite a significant difference. Yeah.
Yeah.
Got a couple of questions relating to your comments and slides about competition. we've obviously got these changes in competition laws. What enforcement action can the Competition and Markets Authority take if someone is proven to be trading unfairly, or is it too soon to know what they're going to do, what the action they'll take?
Yeah, so it's going to depend on every circumstance. They can bring court proceedings against a trader in breach of competition laws. The easiest way to explain what they could do is to give you an example. So last year, the Competition and Markets Authority brought proceedings against Viagogo for the secondary sale of ticketing or resale of tickets. And the CMA sought an order that they basically changed the way they do business. So it was a complete overhaul of its website and an order that they changed the way they presented information. So it was effectively sought as an injunction, as a positive injunction against Viagogo for something that they had to do. And in an absence of Viagogo complying with that court order, proceedings for contempt of court can be started, and the result of that is either custodial sentence or an unlimited fine. So it's going to depend on all the circumstances, what they do and what order they seek from the court. But they can seek an order from the court that you radically change the way you do business. And the way you trade. For example, if you're advertising in a particular manner, they can seek an order that you stop doing that. So they can seek injunctive proceedings against you and an order that you do certain things as well. And failure to comply has really grave consequences.
Right, and you talked about the obviously the changes in the competition law, that's relaxation in some instances. Is there a set time period for that? Have the government said how long those changes will last? Or
no, so at the moment there's no set end date. They're temporary, so they won't be in place forever. And effectively they will end when the Secretary of State considers it as no longer a significant disruption to the supply in the UK. So she may end the relaxation in some industries earlier than others.
Yeah.
Depending on how things pan out. And they do have to give 28 days notice for ending those restrictions.
Yeah. Okay. Right. One final question for you, sort of general question. How will the world of law be different in the future in terms of specifically relating to contracts and that sort of thing? How will you try and ensure that or another question might, what have we learned from this in terms of how the contracts are written?
Yeah, I think in terms of how contracts are written, it will go one way or the other depending on what side of the fence you're sitting on in terms of a contract. Either people will ensure, in a similar way to insurance companies have done, that, for example, pandemics and specifically COVID-19 does not enable a party to rely on getting out of their obligations, or does not mean, for example, that they can seek protection from various policies in light of such situations. And more widely and more relevant to my area is the change in how the courts are run in particular. We're seeing mostly remote hearings taking place, very little in-person hearings are being held. And hopefully, it's yet to be seen, but that will streamline the court process a bit and make it a little bit easier for people to use the court process and make decisions and outcomes to be sought more quickly than they are currently.
Good. So another example of the benefits of the corona in terms of how we do business in the future, sort of moving on through modern technology, maybe more quickly than we might have done otherwise.
Yeah.
Okay.
Definitely.
Great. Well, I think we've covered all the questions which you've put to us today. Those of you who've been watching. If you do have any further queries or questions, then I'm sure Anna will be happy to hear from you. Contact her at Tees Law. Or indeed, if you have a question which you'd like us to put on your behalf or a general query, then do send it to webinar@brentwoodchamber.co.uk. So it's time for me just to let you know about our next webinar. Now we're in June and more people are returning to work. Then we're going to be running the webinars weekly rather than twice weekly. So our next webinar is next Friday morning, and next Friday is National Carers Week actually, and we're going to be featuring an organisation called Carers First, and we're going to be talking about you as an employer. If you have employees who may be working working in inverted commas as carers, so they may be caring for someone at home or a sick relative, for example, and how that can impact on their work and obviously on your business. And there's lots of useful questions which can be answered in terms of if you're employing carers. It may well be that you're employing someone as a carer and you don't actually realise it, and that will be one of the areas which we can talk about. So that's next Friday morning with Carers First, and full details will be available on the Brentwood Chamber of Commerce website, and will be circulating through Brentwood Business Partnership and Brentwood Borough Council as well. And just a reminder, if you didn't join us at the beginning of the webinar, then today's webinar will be available on YouTube later on today, so you can catch up with it, and obviously all the previous webinars as well. So all that remains really is for me to say thanks very much to Ana for presenting today. Very informative and very helpful. Thank you to all of you for watching, and look forward to seeing you all again next Friday. Have a great weekend. Thank you.